10. 10 existing law means any law, ordinance, order, bylaw, rule or regulation passed or made before the commencement of the constitution by any legislature, authority or person having power to make such a law, ordinance, order, bylaw, rules or regulation. 11. Federal courts means the Federal Court constituted under the Government of India Act 1935. 2. Goods include all materials, commodities and articles. 12a. Goods and services tax means the tax on supply of goods or services or both, except taxes on the supply of alcohol, liquor for human consumption. 13. Guarantee includes any obligation undertaken before the commencement of this constitution to make payments in the event of the profit of an undertaking failing short of a specified amount. 14. High Court means the court which is deemed for the purpose of this constitution to be a high court for any state and includes a. Any court in the territory of India considered or reconstituted under the constitution as a high court, and b. Any other court in the territory of India which may be declared by Parliament by law to be a high court for all or any of the purpose of the constitution. 15. Indian state means any territory which the government of the Dominion of India recognized as such a state. 16. Part means a part of the constitution. 17. Person means person, whether contributory or not, for any kind whatsoever, payable to or any in respect of any person, and includes retired pay so payable, a gratuity so payable, and any sum or sums so payable by way of the return with or without interest thereon, or any other addition thereto or subscription to a provident fund. 18. Proclamation of emergency means proclamation issued under clause 1 of article 352. 19. Public notification means a notification in the Gazette of India, or as the case may be, the official gazette of a state. 20. Railway does not include a tramway wholly within the municipal area, or b. any other line of communication wholly situated in one state and declared by Parliament by law not to be a railway. 22. Rules means the prince, chief or other person who at any time before the commencement of the constitution. 26. Amendment Act 1971 was recognized by the President as the ruler of an Indian state, or any person who at any time before such commencement was recognized by the President as as the successor of such ruler. Article 23. Schedule means a schedule of the Constitution. Article 24. Scheduled caste means such caste, races or tribes or a part of a group with such caste, races or tribes are deemed under Article 341 to be scheduled caste for the purpose of this Constitution. 25. Scheduled tribe means such tribes or tribal communities as part of the groups within such tribes or tribal communities as are deemed under Article 342 to be scheduled tribe for the purpose of this Constitution. 26. Securities include stock. 26A. Services mean anything other than goods. 26B. State with reference to Article 246A, 268, 269, 269A and Article 279A includes the Union Territory with legislature. 27. Subclauses means subclause of the clause in which the expression occurs. 28. Taxation includes the imposition of any tax or imposed, whether general or local or special, and tax shall be constituted accordingly. 29. Tax on income includes a tax in the nature of an excess profit tax. 29A. Tax on the sale or purchase of goods includes a tax on the transfer otherwise than in pursuance of a contract of the property in any goods of case, deferred payment or other valuable consideration. B. A tax on the transfer of property in goods, whether as goods or in some other form involved in the execution of a works contract. C. A tax on the delivery of goods on hire purchase or any system of payment by installments. D. A tax on the transfer of the height to use any goods or any purpose, whether or not for a specified period, for case, deferred payment or other valuable consideration. E. A tax on the supply of goods by any unincorporated association or body or person to a member thereof for cash, deferred payment or other valuable consideration. F. A tax on the supply by way of or as part of any service or of any other manner whatsoever of goods, being good or any other article for human consumption or any drink, whether or not intoxicating, where such supply or service is of cash, deferred payment or other valuable consideration, and such transfer, delivery or supply of goods shall be deemed to be sale of those goods by the person making the transfer, delivery or supply, and purchase of those goods by the person of whom such transfer, delivery or supply is made. 30. Union territory means any union territory is specified in the first schedule and includes any other territory comprised within the territory of India but not specified in the schedule. Article 367. Interpretation. 1. Unless the context otherwise requires, the General Clause Act 1987 shall, subject to any adaptation and modification that may be made wherein under Article 352 apply for the interpretation of this constitution as it applies for the interpretation of an act of the legislature of the Dominion of India. 2. Any reference in this constitution to acts or laws of or made by parliament or to acts or laws of or made by the legislature of a state shall be construed as including a reference to an ordinance made by the president or to an ordinance made by the governor as the case may be. 3. For purpose of the constitution, foreign state means any state other than India, provided that subject to the provisions of any law made by parliament, the parliament may by order declare any state not to be foreign state for such purpose as may be specified in the order. The Constitution of India, Part 20, Amendment of the Constitution, Article 368, Power of Parliament to amend the Constitution and procedure thereof. 1. Anything in the Constitution, Parliament may, in exercise of its constituent power, amend by way of addition, variation, or repeal any revision of this Constitution in accordance with the procedure laid down in this article. 2. An amendment of this Constitution may be initiated only by the introduction of a bill for the purpose in either House of Parliament, and when the bill is passed in each House by majority of the total membership of that House and by a majority of not less than 2/3 of the members of that House present and voting, it shall be presented to the President, who shall give his assent to the bill, and thereupon the Constitution shall stand amended in accordance with the terms of the bill, provided that if such amendment seeks to make any changes in Article 54, Article 55, Article 73, Article 162, Article 241 or Article 279A or Chapter 4 or Part 5, Chapter 5 of Part 6 or Chapter 1 of Part 11, or C. any of the list in the 7th schedule, or D. the representation of states in Parliament, or E. the provisions in this article. The amendments are also required to be ratified by the legislature of not less than 1/2 of the states by resolution to that effect passed by those legislatures before the bill making provision for such amendment is presented to the President for assent. 3. Nothing in Article 13 shall apply to any amendment made under this article. 4. No amendment of this Constitution, including the provisions of Part 3 made for purporting to have been made under this article, whether before or after the commencement of Section 55 of the Constitution, 42nd Amendment Act 1976, shall be called in questions in any court on any ground. 5. For the removal of doubts, it is hereby declared that there shall be no limitation whatever on the constituent power of the Parliament to amend by way of addition, variation or repeal the provisions of this constitution under this article. The Constitution of India, Part 21, Temporary, Transitional and Special Provisions, Article 369, temporary power to Parliament to make laws with respect to certain matters in the state list as if they were matter in the concurrent list. Notwithstanding anything in this constitution, Parliament shall during the period of 5 years from the commencement of this constitution have power to make laws with respect to following matters as if they were enumerated in the concurrent list, namely: A. Trade and commerce with a state in and the production, supply and distribution of cotton or woolen textile, road cotton including ginned cotton or unginned cotton, or kapas, cotton seed, paper include newsprint, food stuff including edible oil seed and oil, cattle fodder including oil cakes and other concentrates, coal including coke and derivatives of coal, iron, steel and mica. B. Offences against law with respect to any of the matter mentioned in clauses A. Jurisdiction and powers of all courts except the Supreme Court with respect to any of those matters, and fees in respect of any of those matters but not including fees taken in any court. But any law made by Parliament which Parliament would not, but for the provisions of this article, have been competent to make shall, to the extent of incompetency cases, to have effect on the expiration of the said period, except or respect things done or omitted to be done before the expiration thereof. Article 370, temporary provisions with respect to the state of Jammu and Kashmir. 1. Notwithstanding anything in this constitution, A. The provisions of Article 238 shall not apply in relation to the state of Jammu and Kashmir. B. The power of Parliament to make laws for the said state shall be limited to: 1. Those matter in the union list and the concurrent list which, in consultation with the government of the state, or declared by the President to correspond to matters specified in the instrument of association governing the accession of the state to the Dominion of India, as the matter with respect to which the Dominion legislature may make laws for the state, and 2. Such other matters in the said list as with the concurrence of the government of the state, the President may by order specify. Explanation. For the purpose of this article, the government of the state means the person for the time being recognized by the President as the Maharaja of Jammu and Kashmir, acting on the advice of Council of Ministers for the time being in force under the Maharaja Proclamation dated the 5th day of March 1948. C. The provisions of Article 1 and of the article shall apply in relation to that state. D. Such of the provisions of this constitution shall apply in relation to the state subjected to such exception and modification as the President may by order specify, provided that no such order which relates to the matter specified in the instrument of association of the state referred to in paragraph 1 of subclause B shall be issued except in consultation with the government of the state, provided further that no such order which relates to the matter other than those referred to in the last proceeding proviso shall be issued except with the consent of the government. 2. If the concurrence of the government of the state referred to in paragraph 2 of subclause B of clause 1 or in the second proviso to subclause D of the clause B given before the Constituent Assembly for the purpose of framing of Constitution of the state in convened, it shall be placed before such assembly for such decision as it may take thereon. 3. Notwithstanding anything in the foregoing provisions of this article, the President may by public notification declare that this article shall cease to be operative or shall be operative only with such exceptions and modification and from such date as may be specified, provided that the recommendation of the Constituent Assembly of the state referred to in clause 2 shall be necessary before the President issues such notification. Article 371 special provisions with respect to the states of Maharashtra and Gujarat. 2. Notwithstanding anything in this constitution, the President may by order made with respect to the state of Maharashtra or Gujarat provide for any special responsibility of the governor. 4. A. The establishment of separate development board for Vidarbha, Maharashtra or rest of the Maharashtra, or as the case may be Saurashtra, Kutch and the rest of the Gujarat, with the provisions that the report on the working of each of these boards will be placed each year before the State Legislative Assembly. B. The equitable allocation of funds for developmental expenditure over the said areas subject to the requirements of the state as a whole, and C. On equitable arrangement providing adequate facility for technical education and vocational training and adequate opportunities for employment in service under the control of the state government in respect of all the said areas subject to the requirements of the state as a whole. Article 371A special provision with respect to state of Nagaland. Notwithstanding anything in the constitution, A. No act of parliament in respect of 1. Religious or social practices of the Nagas. 2. Naga communities law and procedure. 3. Administration of civil and criminal justice involving decision according to Naga customary law. 4. Ownership and transfer of land and its resources supply shall apply to the state of Nagaland unless the Legislative Assembly of Nagaland by a resolution so decides. B. The government of Nagaland shall have special responsibility with respect to law and order in the state of Nagaland or so long as, in his opinion, internal disturbance occurring in the Naga Hills, Thenswang area immediately before the formation of the state, continue therein or in any part thereof, and in the discharge of his functions in relation thereto, governor shall, after consulting the council of ministers, exercise his individual judgment and as the action to be taken, provided that if any questions arise whether any matter is or is not a matter as respects which the governor is under the sub-clause required to act in the exercise of his individual judgment, the decision of the governor in his discretion shall be final, and the validity of anything done by the governor shall not be called in question on the ground that he ought or ought not to have acted in the exercise of his individual judgment. Provided further that if the president on receipt of a report from the governor or otherwise is satisfied that it is no longer necessary for the governor to have special responsibility with respect to law and order in the state of Nagaland, he may by order direct the governor shall case to have such responsibility with respect from such date as may be specified in the order. C. In making his recommendation with respect to any demand for a grant, the governor of Nagaland shall ensure that any money provided by the government of India out of consolidated fund of India for any specified service or purpose is included in the demand for a grant relating to the service or purpose and in any other demand. D. As from such date as the governor of Nagaland may by public notification in this behalf specify there shall be established a regional council for the Tusang district consisting of 35 members, and the governor shall in his discretion make rules providing for 1. The composition of the regional council and the manner in which the members of the regional council shall be chosen, provided that the deputy commissioner of the Swan district shall be the chairman ex officio of the regional council, and the vice chairman of the regional council shall be elected by the members thereof from amongst themselves. 2. The qualification for being chosen as and for being members of the regional council. 3. The term of office of and the salaries of allowances, if any, to be paid to members of the regional council. 4. The procedure and conduct of business of the regional council. 5. The appointment of officer and staff of the regional council and their condition of services. And 6. Any other matters in respect of which it is necessary to make rules for the constitution and proper functioning of the regional council. 2. notwithstanding anything in this constitution for the period of 10 years from the date of the formation of the state of Nagaland, or for such further period as the governor may, on the recommendation of the regional council, by public notification, specify in this behalf. A. The administration of the Swang district shall be carried on by the governor. B. Where any money is provided by the government of India to the government of Nagaland to meet the requirements of the state of Nagaland as a whole, the governor shall in his discretion arrange for all equitable allocation of that money between the Tuansang district and the rest of the state. C. No act of the legislature of Nagaland shall apply to Tuansang district unless the governor or the recommendation of the regional council by public notification so direct, and governor in giving such direction with respect to any such act may direct that the act shall in its application to the Tuansang district or any part thereof have effect subject to such exception or modifications as the governor may specify on the recommendation of regional council. Provided that any directions given under this subclause may be given so as to have a retrospective effect. D. The governor may make regulation for the peace, progress and good government of the Tuansang district, and any regulation so made may repeal or amend with retrospective effect, if necessary, any act of parliament or any other law which is for the time being applicable to that district. E1. One of the members representing the Tuansang district in the Legislative Assembly of Nagaland shall be appointed Minister for Tuansang Affairs by the Governor on the advice of the Chief Minister, and the Chief Minister in tendering his advice shall act on the recommendation of the majority of the members as aforesaid. 2. The Minister of Tuansang Affairs shall deal with and have direct access to the governor on all matters relating to the Tuansang district, but he shall keep the Chief Minister informed about the same. F. Notwithstanding anything in the foregoing provisions of this clause, the final decision on all matters relating to Tuansang district shall be made by the governor in his discretion. G. In Article 54 and 55, clauses 4 of Article 80, reference to the elected member of the Legislative Assembly of a state or each such member shall include reference to the members or member of the Legislative Assembly of Nagaland elected by the Regional Council established under this article. H. In Article 170, 1. Clause 1 shall in relation to the Legislative Assembly of Nagaland have effect as if for the word 60 the word 46 had been substituted. 2. In the said clause, the reference to a direct election from territorial constituencies in the state shall include election by the member of the regional council established under this article. 3. In case in clause 2 and 3, reference to territorial constituencies shall mean a reference to territorial constituency in the Kohima and Mokokchung districts. 3. If any difficulty arises in giving effect to any of the foregoing provisions of this article, the President may by order do anything including any adaptation or modification of any other article which appears to him to be necessary for the purpose of removing that difficulty, provided that no such order shall be made after the expiration of 3 years from the date of the formation of the state of Nagaland. Explanation: in this article, the Kohima, Mokokchung and Tuansang districts shall have the same meaning as in the state of Nagaland Act 1962. Article 371b, special provision with respect to the state of Assam. Notwithstanding anything in this constitution, the President may, by order made with respect to the state of Assam, provided for the constitution and functions of the committee of the Legislative Assembly of the state, consisting of members of that assembly elected from the tribal areas, is specified in part 1 of the table appended paragraph 20 of the 6th schedule, and such member of other members of that assembly as may be specified in the order, and for the modification to be made in the rules of procedure of that assembly for the constitution and proper functioning of such committee. Article 371c, special provisions with respect to the state of Manipur. 1. Notwithstanding anything in this constitution, the President may, by order made with respect to the state of Manipur, provided for the constitution and functions of a committee for the Legislative Assembly of the state, consisting of members of the assembly elected from the hill areas of the state, for the modification to be made in the rules of business of the government and in the rule of procedure of the Legislative Assembly of the state, and for the special responsibility of the governor in order to secure the proper functioning of such committee. 2. The governor shall annually or whenever so required by the President make a report to the President regarding the administration of the hill areas in the state of Manipur, and the executive power of the Union shall extend to the giving of directions so the state as to the administration of the said areas. Explanation: in this article, the expression hill areas means such area as the President may by order declare to be hill areas. Article 371d, special provisions with respect to the state of Andhra Pradesh or the state of Telangana. 1. The President may by order made with respect to the state of Andhra Pradesh or the state of Telangana provide having regard to the requirement of each state for equitable opportunities and facilities for the people belonging to different parts of such state in the matter of public employment and in the matter of education, and different provisions may be made for various parts of the states. 2. An order made under clause 1 may in particular require the state government to organize any class or classes for post of a civil service of or any clause or clauses of civil post under the state into different local cadres for different parts of the state and allowed in accordance with such principles and procedure as may be specified in the order the persons holding such post to the local cadre so organized. B. Specify any part or parts of the state which shall be regarded as the local area. 1. For direct recruitment of post in any local cadre, whether organized in pursuance of an order under this article of constituted otherwise under the state government. 2. For the direct recruitment of to post in any cadre under any local authority within the state. And 3. For the purpose of admission to university within the state or any other educational institution which is subject to the control of the state government. C. Specify the extent to which, the manner in which, and the conditions subject to which preference or reservation shall be given or made. 1. In the matter of direct recruitment, the post in any such cadre referred to in subclause B as may be specified in this behalf in the order. 2. In the matter of admission to any such university or other educational institution referred to in subclause B as may be specified in this behalf in the order. 2. Or in favor of candidate who have resided or studied for any period specified in the order in the local area in respect of such cadre, university or other educational institution as the case may be. 3. The President may by order provide for the constitution of an administrative tribunal for the state of Andhra Pradesh and for the state of Telangana to exercise such jurisdiction powers and authority, including any jurisdictions, powers and authority which immediately before the commencement of the Constitution 32nd Amendment Act 1973 was exercisable by any court other than the Supreme Court or by any tribunal or other authority as may be specified in the order with respect to the following matters, namely: A. Appointment, allotment or promotion to such a class or classes of post in any civil services of the state or to such class or classes of civil post under the state or such class or classes of post under the control of any local authority within the state as may be specified in the order. B. Seniority of persons appointed, allotted or promoted to such class or classes of post in any civil services of the state or to such class or classes of civil post under the state or to such class or classes of post under the control of any local authority within the state as may be specified in the order. C. Such other condition of service of persons appointed, allotted or promoted to such class or classes of post in any civil service of the state or such class or classes of civil post under the state or such class or classes of post under the control of any local authority within the state as may be specified in the order. 4. An order made under clause 3 may a. authorize an administrative tribunal to receive representation for the redress of grievances relating to any matter within its jurisdiction, as the President may specify in the order, and make such orders thereon as the administrative tribunal deems fit. B. Contains such provisions with respect to the powers and authorities and procedure of the administrative tribunal, including provisions with respect to the powers of administrative tribunal to punish for contempt of itself, as the President may deem necessary. C. Provided for the transfer of administrative tribunal of such class of proceedings being proceedings relating to matter within the jurisdiction and pending before any court other than the Supreme Court or tribunal or other authority immediately before the commencement of such order as may be specified in the order. D. Contains such supplemental, incidental and consequential provisions, including provisions as to fees and as to limitations, evidence, or of the application of any law for the time being in force, subject to any exceptions or modification as the President may deem necessary. 5. The order of the administrative tribunal finally disposing of any case shall become effective upon its confirmation by the state government or on the expiry of 3 months from the date on which the order is made, whichever is earlier, provided that the state government may by special order made in writing and for reasons to be specified therein modified or annual any order of the administrative tribunal for it becomes effective, and in such a case the order of administrative tribunal shall have effect only in such modified form or be of no effect as the case may be. 6. Every special order made by the state government under the provisions clause 5 shall be laid as soon as may be after it is made before both house of the state legislature. 7. The High Court of the state shall not have any powers of superintendence over the administrative tribunal, and no court other than the Supreme Court or tribunal shall exercise any jurisdiction, power or authority in respect of any matter subject to the jurisdiction, power or authority of or in relation to the administrative tribunal. 8. If the President is satisfied that the continued exercise of the administrative tribunal is not necessary, the President may by order abolish the administrative tribunal and make such provisions in such order as he may deem fit for the transfer and disposal of cases pending before the tribunal immediately before such abolition. 9. Notwithstanding any judgment, decree or order of any court, tribunal or authority. A. No appointment, posting, promotion or transfer of any person 1. Made before the first day of November 1956 to any post under the government of or any local authority within the state of Hyderabad as it exists before that date, or 2. Made before the commencement of the Constitution 32nd Amendment Act 1973 to any post under the government of or any local or other authority within the state of Andhra Pradesh, and P. No action taken or thing done by or before any person referred to in subclauses A shall be deemed to be eligible for void or ever to have become illegal or void merely on the ground that the appointment, posting, promotion or transfer of such person was not made in accordance with any law then in force, providing for any requirement as to residence within the state of Hyderabad or as the case may be within any part of the state of Andhra Pradesh in respect of such appointment, posting, promotion or transfer. 10. The provisions of this article and of any order made by the President thereunder shall have effect notwithstanding anything in any other provisions of the Constitution or any other law for the time being in force. Article 371E Establishment of Central University in Andhra Pradesh. Parliament may by law provide for the establishment of a university in the state of Andhra Pradesh. Article 371F Special provisions with respect to the state of Sikkim, notwithstanding anything in this constitution. A legislative assembly of the state of Sikkim shall consist of not less than 30 members. B. As from the date of commencement of the constitution, 36th Amendment Act 1975, hereafter in this article referred to as the appointed day. 1. The Assembly for Sikkim formed as a result of the election held in Sikkim in April 1974 with 32 members elected in the said elections, hereinafter referred to as the sitting members, shall be deemed to be the Legislative Assembly of the state of Sikkim duly constituted under this constitution. 2. The sitting members shall be deemed to be the member of Legislative Assembly of the state of Sikkim duly elected under this constitution. And 3. The said Legislative Assembly of the state of Sikkim shall exercise the powers and perform the functions of the Legislative Assembly of the state under this constitution. C. In the case of assembly deemed to be Legislative Assembly of the state of Sikkim under clause B, the reference to the period of 5 years in clause 1, the article 172 shall be construed as reference to a period of 4 years, and the said period of 4 years shall be deemed to commence from the appointed day. D. Until other provisions are made by Parliament by law, there shall be allotted to the state of Sikkim on seat in the House of People, and the state of Sikkim shall have one parliamentary constituency to be called the Parliamentary Constituency for Sikkim. E. The representative of the state of Sikkim in the House of People in existence on the appointment day shall be elected by the members of Legislative Assembly of the state of Sikkim. F. Parliament may, for the purpose of protecting the rights and interest of the different sections of the population of Sikkim, make provision for the number of seats in the Legislative Assembly of the state of Sikkim which may be filled by candidate belonging to such section, and for the delimitation of the assembly constituencies from which candidates belong to such section along may stand for election to the Legislative Assembly of the state of Sikkim. G. The Governor of Sikkim shall have special responsibility for peace and for an equitable arrangement for ensuring the social and economic advancement of different sections of the population of Sikkim, and in the discharge of his special responsibility under this clause, the Governor of Sikkim shall, subject to such direction as the President may from time to time deem fit to issue, act in his discretion. H. All property and assets, whether within or outside the territories comprised in the state of Sikkim, which immediately before the appointment day were vested in the government of Sikkim or in any other authority or in any person for the purpose of the government of Sikkim, shall as from the appointment day vest in the government of the state of Sikkim. I. The High Court function as such immediately before the appointment day in the territories comprised in the state of Sikkim shall, on and from the appointment day, be deemed to be the High Court for the state of Sikkim. J. All courts of civil, criminal or revenue jurisdiction, all authorities and all officers, judicial, executive and ministerial throughout the territory of the state of Sikkim shall continue on and from the appointment day to exercise their respective functions subject to the provisions of this constitution. K. All laws in force immediately before the appointment day in the territories comprised in the state. State of Sikkim or any part thereof shall continue to be force therein until amended or repealed by a competent legislature or other competent authority. L. For the purpose of facilitating the application of any such law as is referred to in clause K in relation to the administration of the state of Sikkim and for the purpose of bringing the provisions of any such law into in accordance with the provisions of the constitution, the President may within 2 years from the appointed day by order make such adaptations and modification of the law, whether by way of repeal or amendment as may be necessary or expedient, and thereupon every such law shall have effect subject to the adaptation and modification so made, and any such adaptation or modification shall not be questioned in any court of law. M. Neither the Supreme Court nor any other court shall have jurisdiction in respect of any dispute or other matter arising out of any treaty, agreement, engagement or other similar instrument relating to Sikkim which was entered into or executed before the appointment day, and to which the government of India or any of its predecessors government was a party, but nothing in this clause shall be construed to derogate from the provisions of Article 143, and the President may by public notification extend with such restriction or modification as the thinks fit to the state of Sikkim any enactment which is in force in the state in India at the date of the notification. O. If any difficulty arise in giving effect to any of the foregoing provisions of this article, the President may by order do anything including any adaptation or modification of any other article which appears to him to be necessary for the purpose of removing the difficulty, provided that no such order shall be made after the expiry of 2 years from the appointed day. P. All things done and all action taken in or in relation to the state of Sikkim or in territories comprised therein during the period commencing on the appointment day and ending immediately before the date on which Constitution 36 Amendment Act 1975 received the assent of the President shall, in so far as they are in conformity with the provisions of this Constitution as amended by the Constitution 36 Amendment Act 1975, be deemed for all purposes to have been validly done or taken under this Constitution as so amended. Article 371G, special provision with respect to the state of Mizoram. Notwithstanding anything in this Constitution, A. No act of Parliament in respect of 1. Religious or special practices of the Mijos. 2. Mizo customary law and procedure. 3. Administration of civil and criminal justice involving decisions according to Mizo customary law. 4. Ownership and transfer of land shall apply to the state of Mizoram unless the Legislative Assembly of the state of Mizoram by a resolution so decides, provided that nothing in this clause shall apply to any central act in force in the Union Territory of Mizoram immediately before the commencement of the Constitution 53rd Amendment Act 1986. B. The Legislative Assembly of the State Mizoram shall consist of no less than 40 members. Article 371H, special provisions with respect to the state of Arunachal Pradesh. Notwithstanding anything in this Constitution, A. The Governor of Arunachal Pradesh shall have special responsibilities with respect to law and order in the state of Arunachal Pradesh and in the discharge of his functions in relation thereto. The Governor shall, after consulting the Council of Ministers, exercise his individual judgment as to the action to be taken, provided that if any questions arise whether any matter is or is not a matter as respects which the Governor is under this clause required to act in the exercise of his individual judgment, the decision of the Governor in his discretion shall be final, and the validity of anything done by the Governor shall not be called in question on the ground that he ought or ought not to have acted in the exercise of his individual judgment. Provided further that if the President on receipt of a report from the Governor or otherwise is satisfied that it is no longer necessary for the Governor to have his special responsibility with respect to law and order in the state of Arunachal Pradesh, he may by order direct the Governor shall cease to have such responsibility with effect from such date as may be specified in the order. B. The Legislative Assembly of the State of Arunachal Pradesh shall consist of not less than 30 members. Article 371I. Special provisions with respect to the state of Goa. Notwithstanding anything in this Constitution, the Legislative Assembly of the State of Goa shall consist of not less than 30 members. 371J. Special provisions with respect to the state of Karnataka. 1. The President may, by order made with respect to state of Karnataka, provide for any special responsibility of the governor for A. Establishment of a separate development board for the Hyderabad Karnataka region, with the provisions that the report on the working of the board will be placed such each year before the State Legislative Assembly. B. Equitable allocation of funds for developmental expenditure over the said region, subject to the requirement of the state as a whole. And C. Equitable opportunities and facilities for the people belonging to the said region in the matters of public employment, education and vocational training, subject to the requirements of the state as a whole. Two. Any order made under subclause C of clause 1 may provide for A. Reservation of proportion of seats education and vocational training institution in the Hyderabad Karnataka region for students who belong to that region by birth or by domicile. And B. Identification of post or classes of post under the state government and in any body or organization under the control of state government in the Hyderabad Karnataka region, and reservation of proportion of such post for persons who belong to that region by birth or by domicile, and for appointment thereto by direct recruitment or by promotion or in any other manner as may be specified in the order. Article 372. Continuance in force of existing laws and their adaptation, notwithstanding the repeal by this Constitution of the enactment referred to Article 395, but subject to the other provisions of this Constitution. All the law in force in the territory of India immediately before the commencement of this Constitution shall continue in force therein until altered or repealed or amended by the competent legislature or other competent authority. 2. For the purpose of bringing the provisions of any law in force in the territory of India into accord with the provisions of this Constitution, the President may by order make such adaptation and modification of such law, whether by way of repeal or amendment, as may be necessary for expedient, and provide that the law shall, as from such date as may be specified in the order, have effect subject to the adaptation and modification so made, and may such adaptation and modification shall not be questioned in any court of law. 3. Nothing in clause 2 shall be deemed A. to empower the President to make any adaptation or modification of any law after the expiration of 3 years from the commencement of this Constitution, or B. to prevent any competent legislature or other competent authority from repealing or amending any law, modified by the President under the said clause. Explanation 1. The expression law in force in the article shall include a law passed or made by a legislature or other competent authority in the territory of India before the commencement of this constitution and not previously repealed, notwithstanding that it or parts of it may not be then in the operation either at all or in particular areas. Explanation 2. Any law passed or made by legislature or other competent authority in the territory of India which immediately before the commencement of this constitution had extraterritorial effect as well as effect in the territory of India shall subject to any such adaptation and modification as aforesaid continue to have such extraterritorial effect. Explanation 3. Nothing in this article shall be construed as continuing any temporary law in force beyond the date fixed for its expiration or the date on which it would have expired if this constitution had not come into force. Explanation 4. An ordinance promulgated by the governor of a province under section 88 of the Government of India Act 1935 and in force immediately before the commencement of this constitution shall, unless withdrawn by the governor for the corresponding state earlier, cease to operate at the expiration of 6 weeks from the first meeting after such commencement of the Legislative Assembly of the state functioning under clause 1 of article 382, and nothing in this article shall be construed as continuing any such ordinance in force beyond the said period. Article 372A. Power of President to adapt laws. 1. For the purpose of bringing the provisions of any law in force in India or any part thereof immediately before the commencement of the Constitution 7th Amendment Act 1956 into accord with the provisions of the Constitution as amended by that act, the President may by order made before the first day of November 1957 make such adaptation and modification of the law, whether by way of repeal or amendment as may be necessary or expedient, and provide that law shall as from such date as may be specified in the order have effect subject to the adaptation and modification so made, and any such adaptation or modification shall not be questioned in any court of law. 2. Nothing in clause 1 shall be deemed to prevent a competent legislature or other competent authority from repealing or amending any law adopted or modified by the President under the said clause. Article 373. Power of President to make order in respect of persons under preventive detention in certain cases until provision is made by Parliament under clause 7 of Article 22 or until the expiration of 1 year from the commencement of this constitution, whichever is earlier. The said article shall have effect as if for any reference to Parliament in clause 4 and 7 thereof there were substituted a reference to the President, and for any reference to any law made by Parliament in those clauses there was substituted a reference to an order made by the President. Article 374 provisions as to judges of the federal court and proceedings pending in the federal court or before His Majesty in council. 1. Judges of the federal court holding office immediately before the commencement of this constitution shall, unless they have elected otherwise, become on such commencement the judges of the Supreme Court, and shall thereupon be entitled to such salaries and allowances and such rights in respect of leave of absence and pension as are provided for under Article 125 in respect of the judges of the Supreme Court. 2. All suits, appeals, proceedings, civil or criminal pendings in the federal court at the commencement of this constitution shall stand removed of the Supreme Court, and Supreme Court shall have jurisdiction to hear and determine the same, and judgment and orders of the federal court delivered or made before the commencement of the constitution shall have the same force and effect as if they had been delivered or made by the Supreme Court. 3. Nothing in this constitution shall operate to invalid or exercise the jurisdiction by His Majesty of Council to dispose of appeals and petition from or in respect of any judgment, decree or order of any court within the territory of India, in so far as the exercise of such jurisdiction is authorized by law, and any order of His Majesty in council made on any such appeal or petition after the commencement of this constitution shall for all purpose have effect as if it were an order or decree made by the Supreme Court in the exercise of the jurisdiction conferred on such court by this constitution. 4. On and from the commencement of this constitution, the jurisdiction of the authority functioning as the privy council in the state specified in Part B of the first schedule to entertain and dispose of appeals and petition from or in respect of any judgment, decree or order of any court within the state shall cease, and all appeals and other proceedings pending before the said authority at such commencement shall be transferred to and disposed of by the Supreme Court. 5. Further provisions may be made by Parliament by law to give effect to the provisions of this article. Article 375. Courts, authorities and officers to continue to function subject to the provisions of the Constitution. All courts of civil, criminal, revenue, jurisdiction, all authorities and all officers, judicial, executive and ministerial throughout the territory of India shall continue to exercise their respective functions subject to the provisions of the Constitution. Article 376. Provisions as the judges of high courts. 1. Notwithstanding anything in clause 2 of Article 217, the judges of the high court in any province holding office immediately before the commencement of this constitution shall, unless they have elected otherwise, become on such commencement the judges of the high court in the corresponding state, and shall thereupon be entitled to such salaries and allowances and to such rights in respect of leave of absence and pensions as are provided 4 under Article 221 in respect of the judges of such High Court. Any such judge shall notwithstanding that he is not a citizen of India be eligible for appointment as Chief Justice of such High Court or as Chief Justice or other judge of any other High Court. 2. The judges of High Court in any Indian state corresponding to any state specified in Part B of the first schedule holding office immediately before the commencement of this constitution shall, unless they have elected otherwise, become on such commencement the judges of the High Court in the state so specified, and shall notwithstanding anything in clause 1 and clause 2 of Article 217 but subject to the proviso to clause 1 of that article, continue to hold official office until the expiration of such period as the President may by order determined. 3. In this article, the expression judge does not include an acting judge or an additional judge. Article 377 provisions as to Comptroller and Auditor General of India. The Auditor General of India holding office immediately before the commencement of this constitution shall, unless he has elected otherwise, become on such commencement the Comptroller and Auditor General of India, and shall thereupon be entitled to such salaries and to such rights in respect of leave and absence and pensions as are provided for under clause 3 and Article 148 in respect of the Comptroller and Auditor General of India, and be entitled to continue to hold office until the expiration of his term of office as determined under the provisions which were applicable to him immediately before such commencement. Article 378 provisions as the Public Service Commission. 1. The members of the Public Service Commission for the Dominion of India holding office immediately before the commencement of this constitution shall, unless they have elected otherwise, become on such commencement the members of the Public Service Commission for the Union, and shall, notwithstanding anything in clause 1 and 2 of the Article 316 but subject to the proviso to clause 2 of the article, continue to hold office until the expiration of their term of office as determined under the rules which were applicable immediately before such. Commencement to such members. 2. The members of Public Service Commission of a province or the Public Service Commission serving the need of a group of provinces holding office immediately before the commencement of this constitution shall, unless they have elected otherwise, become on such commencement the member of the Public Service Commission for the corresponding state, or the member of the Joint State Public Service Commission serving the need of the corresponding state, as the case may be, and shall, notwithstanding anything in clause 1 and 2 of Article 316 but subject to the proviso to clause 2 of that article, continue to hold office until the expiration of their term of office as determined under the rules which were applicable immediately before such commencement to such members. Article 378A special provisions as to duration of Andhra Pradesh Legislative Assembly. Article 378A special provisions as to duration of Andhra Pradesh Legislative Assembly. Notwithstanding anything contained in Article 172, the Legislative Assembly of the State of Andhra Pradesh as constituted under the provisions of Section 28 and 29 of the State Recognition Act 1956 shall, unless sooner dissolved, continue for a period of 5 years from the date referred to in the said section 29 and no longer, and the expiration of the said period shall operate as the dissolution of the Legislative Assembly. Article 379 to 391 RAP by the Constitution 7th Amendment Act 1956 and Section 29 and SCH. Article 392 Power of the President to remove difficulties. 1. The President may, for the purpose of removing any difficulty, particularly in relation to the transition from the provisions of the Government of India Act 1935 to the provisions of this Constitution, by order direct that this Constitution shall, during such period as may be specified in the order, have effect subject to such adaptation, whether by way of modification, addition or omission, as he may deem to be necessary or expedient, provided that no such order shall be made after the first meeting of Parliament duly constituted under Chapter 2 of Chapter 5. 2. Every order made under Clause 1 shall be laid before the Parliament. 3. The power conferred on the President by this article, by Article 324, by Clause 3 of Article 367 and by Article 391 shall, before the commencement of this Constitution, be exercisable by the Governor General of the Dominion of India. The Constitution of India, Part 22, short title Commencement Authoritative Text in Hindi and Repeals. Article 393, short title The Constitution may be called the Constitution of India. Article 394, Commencement. This article and Article 5, 6, 7, 8, 9, 60, 324, 366, 367, 379, 380, 388, 391, 392 and 393 shall come into force at once, and the remaining provision of this Constitution shall come into force on the 26th day of January 1950, which day is referred to in this Constitution as the commencement of this Constitution. 394A Authoritative Text in Hindi language. 1. The President shall cause to be published under his authority A. The translation of this Constitution in Hindi language, signed by the members of the Constituent Assembly with such modification as may be necessary to bring it in conformity with the language, style and terminology adopted in the authoritative text of central acts in the Hindi language, in incorporating therein all amendments of the Constitution made before such publication, and B. The translation in Hindi language of every amendment of this constitution made in the English language. 2. The translation of this constitution and of every amendment thereof published under clauses 1 shall be construed to have the same meaning as the original thereof, and if any difficulty arise in so construing any part of such translation, the President shall cause the same to be revised suitably. 3. The translation of this constitution and of every amendment thereof published under this article shall be deemed to be for all purposes an authoritative text thereof in Hindi language. Article 395 repeals the Indian Independence Act 1947 and the Government of India Act 1935, together with all enactments amending or supplementing the latter act, but not including the abolition of Privy Council Jurisdiction Act 1949, are hereby repealed.